Assalamu alaikum and welcome back to Just Law on IQRA TV. I'm your host Ilyas Bulbulia. This is the second part of the show. We've got a caller waiting, so let's take that call before we return to our topic. Hello, Assalamu alaikum.
हेलो
Hello.
अस्सलाम सर
जी वालेकुम सलाम जी. How are you?
सर अभी मेरी बात हो रही थी कॉल ड्रॉप हो
Oh,
गई
ये
थी
ड्रॉप हो गया?
तो
नो प्रॉब्लम. नो
जी जी
प्रॉब्लम. जी.
तो असल में मैं ये जानना चाह रहा था कि एक तो मुझे वो केस का नाम बता दीजिएगा जो आप कह रहे थे आया है।
जी.
दूसरा आप काइंडली मुझे ये बता दीजिएगा ये जो बायोमेट्रिक्स मुझे आए हैं इसका क्या मतलब है कि वो मेरी एप्लीकेशन के लिए पॉजिटिव थिंग है या
जी जी ठीक है. ऑन द सेकंड पॉइंट आई एम नॉट क्लियर. मुझको लगता है कि हो सकता इट कुड बी वन ऑफ टू थिंग्स. इट कुड बी कि could be a positive decision, इसलिए कहते हैं आपको कि बायोमेट्रिक्स एनरोल करो. ऑल्टरनेटिवली इट कुड बी कि उसने पहले आपके बायोमेट्रिक्स लिए नहीं है और वो आपके बायोमेट्रिक्स लेना चाहते हैं.
ये सेकंड टाइम सर उन्होंने लिए हैं। एक दफा जब मैंने फ्रेश क्लेम किया था उस वक्त लिए थे 2 साल पहले अब ये सेकंड टाइम लिए हैं.
सो इट मे वेल बी जस्ट कि आपने फ्रेश क्लेम डाला, इसके लिए वो प्रोसेस करने के लिए वो आपसे ये बायोमेट्रिक्स ले रहे हैं. सो इट्स डिफ़िकल्ट टू टेल कि क्या सिचुएशन है अभी. सो जो भी है वॉट एवर द सिचुएशन इट डजंट रियली मैटर. आप सिर्फ वो आपका बायोमेट्रिक्स दे दो. इट्स डिफ़िकल्ट टू टेल कि उसका आउटकम क्या होगा. जनरली जो है ना फ्रेश क्लेम्स जनरली स्पीकिंग वो इट्स वेरी डिफ़िकल्ट. इन माई एक्सपीरियंस इन 20 केस में एक केस का कोई पॉजिटिव रिस्पॉन्स आता है. जनरली स्पीकिंग फ्रेश क्लेम्स आर क्वाइट डिफ़िकल्ट. इसलिए मैं ये कहता हूँ कि अगर आपका ये फ्रेश क्लेम का रिजेक्शन आ जाए तो एट दैट स्टेज आप ये कंसिडर करो ह्यूमन राइट्स एप्लीकेशन डाल दो. ह्यूमन राइट्स एप्लीकेशन में सिर्फ एक प्रॉब्लम है, फ़ीस का प्रॉब्लम है. इट्स एक्सपेंसिव होता है. रफली पर पर्सन होम ऑफिस की फ़ी है 1033, NHS की फ़ी देनी पड़ती है £500. सो ओवर £1500 पर पर्सन फ़ी पे करनी पड़ती है. That is the problem with a human rights application. मगर in view of the fact कि ये recent case हुआ है और I can't remember the name off the top of my head. What I'll do for next week is I'll get a copy of the case and I will bring it with you. अगर if we had break से पहले अगर बात होती तो मैं check ही कर लेता during the break. But there's a very positive case for you. तो hopefully इससे कोई आपके लिए भी फ़ायदा होगा. But that is only something you need to do. अगर आपका fresh claim उसने reject किया तो at that stage you should look at the human rights claim.
ओके सर.
The only problem with the human rights का सिर्फ ये है कि human rights की फीस का सिर्फ मसला है. आप ट्राई कर सकते हैं कि फ़ीस का एग्जेम्पशन का फॉर्म फिल करके कि आपके पास पैसे नहीं है मगर जनरली स्पीकिंग फ़ी पे करनी ही पड़ती है which is roughly about £1500 per person. But I think it is worth doing because काम हो जाएगा hopefully. So sorry, you got cut off there. But that's the basic position. Okay? If the fresh claim is refused, submit an Article 8 claim based on the children's 7-year residence. Article 8 claim, and obviously within the immigration rules there's a specific rule which says if the children have lived in the United Kingdom for 7 years and it is unreasonable to remove them, then they should be granted a visa to remain in the United Kingdom. Okay. Now, so what we were saying before the break in relation to European nationals is that they need to be doing something in the United Kingdom. After the first 3 months in the United Kingdom, there's no right for European nationals to stay here. They need to be working in self-employment, studying, self-sufficient or looking for work. And it's only if they fall into one of those categories that in 5 years' time, they are able to apply for indefinite leave to remain or permanent residence. And likewise, when their dependent applies for permanent residence, for example, the wife applies for permanent residence, or for example, the children apply for permanent residence, what they will look at is the sponsor, the European national. What has the European national been doing in the United Kingdom? So their whole claim will be dependent not on what they've been doing, because they simply need to be resident in the United Kingdom, but the dependence application will solely rely on what the sponsor, the European national, has been doing. Does the European national fall within one of those categories? Now, let's look at a common problem before we move on, which is the most common problem is gaps in activity, if I can put it that way. So typically you'll see a client, you'll say to the client, look, you need to look at what's happened over the last 5 years. Can you bring your wage slips? Can you bring your bank statements? If you're self-employed, can you bring your accounts, your tax documents, etc.? Now, in one sense, it's easier now to make permanent residence applications, because for every year they don't ask for too many documents. So a P60 per year, if you're self-employed, a tax document for each year that you're self-employed, etc., is normally sufficient. But at the very least, you will need some evidence to demonstrate your activity throughout your 5 years. And what you need to do is ensure that that activity continues. If the job ceases, try and make sure another job is obtained quickly. If not, if you're in self-employment, make sure at the end of the financial year you do your accounts and the requisite tax documents are completed, etc. So you have to be very much meeting the requirements for the duration of your stay here. Now, if you're able to do that, then the process for applying for permanent residence is actually fairly straightforward. The application can either be made online or a paper-based application can be made. Key point there is that, and this is where a lot of people go wrong, so let me just flag up what the key issue at the application stage is. Everybody who submits an application needs to submit valid identity documents. So for the European national, it has to be a valid European passport or a valid national identity card. So it can't be an expired or a photocopied document that you submit. It has to be valid. And likewise, for the dependents, whether it's the wife or the children, likewise, they need valid documents. So in one sense, for European applications, the approach seems to be stricter than normal immigration applications, where expired documents cannot also be used for normal immigration applications. But here, for European applications, you need to make sure that you have valid documents which are in time. So you have a choice. The European national, once he or she demonstrates their activity for 5 years, the wife will then demonstrate that they're married. So there'll be a marriage certificate, will demonstrate residence in the UK. Likewise, the children will demonstrate residence in the United Kingdom. Sometimes for the children, the easiest thing to do is simply get a letter from the school to say they've been attending school from this date to that date. That obviously demonstrates that they've been in the United Kingdom. So that application for permanent residence can be made using the online system, which the Home Office has now developed, which in one sense it's easier because it saves you from completing a 60-70 page form, which is quite confusing because it tries to deal with a lot of different scenarios, whereas the online form specifically takes you to the relevant bits as you answer the questions one after another. So you have a choice. You either make a online application or you make a paper-based application, and you submit your supporting documents to the Home Office. Now, the typical sort of waiting time at the moment is in the region of quite quick, in the region of, in a straightforward case, you could get a decision back in the space of about 2 months in a straightforward case, in 2 to 3 months. So it's not taking the 6 months that it used to take. It could all be done in the space of 2 to 3 months. The key point about these European permanent residence applications is being able to demonstrate treaty rights activity, showing what you've been doing over the last 5 years. And as far as the dependent and the children are concerned, the rights as to how they've been resident in the United Kingdom, whether it is done simply by submitting bills, bank statements, etc., or whether for children it is done by submitting letters from the school confirming residence in the United Kingdom. Now, I'll look at in a second when there's a problem within the marriage, etc., what happens. But in a classic scenario where the parties are together, the children are there as well, that's basically how a permanent residence application is put together. Now, it's important that the European national or the dependent obtains permanent residence, because that is compulsory in order to apply for nationality. Now, it used to be the case many years ago that European nationals could apply for nationality straight away, but that's now changed. They have to apply for permanent residence first, and then after a year of having permanent residence, they're able to apply for nationality at that stage. Now, it therefore becomes important that permanent residence is obtained by the parties. So as I've said, obtain permanent residence after 1 year of continuous residence in the United Kingdom. It is possible to apply for indefinite leave. Now, what we've covered today is the standard application process for somebody who wants to apply for permanent residence. Obviously, there are no doubt going to be many cases where there are complications. For example, there could be a case where the parties have separated, or they have in fact divorced. So the rules that apply to them are different. There may be cases where, for example, the European national who was working in the United Kingdom has become temporarily unable to work because of an illness, because of a sickness that they're suffering from. So it may be temporarily they are unable to work. There could be a situation where, because of an illness, they are permanently incapacitated. So there are various different scenarios which could occur in that 5-year period, and depending on what the situation is determines the rules which will apply to that particular application. So we can't always use the standard route of 5 years documents showing that somebody is working in the UK and the family are resident. There are, in many cases, because 5 years is a long time, there are many cases where there are complications. No, let's just look at one or two of those and look at how we can get round that particular problem. Now, classic situation, and this is not unusual for, in my experience, European nationals who came to the UK when they were much older. For example, they came to the UK because, let's say, in their 50s or 60s, and as time has gone on, they are now suffering from some kind of illness, which means that they are unable to continue working. Now, it is possible in those situations that although they no longer fall into the category of being an employee, being self-employed, being a student, it is still possible, if we can demonstrate that the person has stopped working because of their incapacity, it is still possible for them to apply for permanent residence in the United Kingdom. There are different situations. For example, the other classic situation that you come across, one is where people have become ill. The other is where there's been a breakdown of the relationship. Unfortunately, that's very common as well. Now, there are specific rules which govern what happens in that situation. So, where the relationship has broken down, as far as the European national is concerned, that person is normally not affected because they, as a European national, have the right to continue living in the United Kingdom as long as they're working. The problem is for the dependent. The problem is for the husband or wife, because their right to stay here is dependent on the relationship in terms of the marriage still continuing, and their right to live here is dependent on the European partner continuing to work in the United Kingdom. Now, if there's a problem in the relationship and if the parties divorce, then all is not lost. As far as the dependent is concerned, there is the possibility of living in the United Kingdom legally, and that is the retained rights of residence route that they can follow. So that is the situation which applies where there's been a breakdown in the marriage. Not just a breakdown, the parties have entered or the parties have divorced, and all is not lost in that category if the dependent can satisfy certain requirements. Now, what are those requirements? the dependent finds himself or herself having divorced from the European partner, can they continue living in the United Kingdom? Potentially, if certain requirements are fulfilled. Now, this is a very common situation, unfortunately. So what are those requirements? The first requirement is that their marriage should have lasted for 3 years. Easy to demonstrate. You simply look at when the parties entered into the marriage and you look at when the divorce application was made. Did their marriage last for 3 years? If we can satisfy that requirement, we can then move on to the next requirement, which is that the parties must have lived in the United Kingdom for at least 1 year. So it could well be that the parties married abroad. They could have married, let's say, in Germany. They lived in Germany for 2 years, 3 years, and then came to the United Kingdom and then lived in the United Kingdom for 1 year. That is sufficient. The 3-year marriage can be made up of living abroad in the European country or indeed in any other country. It's only necessary for them to have lived in the UK for 1 year. So that's the second requirement, residence in the United Kingdom for 1 year. The third requirement that needs to be satisfied by a dependent who finds himself or herself having divorced their European national partner is that as at the date the decree absolute is granted by the court, as at that date the European national needs to be in employment or needs to be in self-employment or needs to be a student, etc. They need to be exercising treaty rights. Now, in practice, it becomes difficult sometimes for the European dependent to obtain that kind of evidence from the European nationals. Clearly, they've now separated. Indeed, they have now divorced. And it is difficult for the dependent to go to the former partner, who's the European national, and say, right, what I need to demonstrate for my application is that you were working as at the date of our divorce. Can I get your wage slips? Can I get your bank statements? Can you get me an employment letter, etc.? And it's in most cases inevitable that the former partner will say, look, we've divorced. Obviously, there were problems in our marriage which has resulted in this divorce. I'm not going to assist you at all. So, which is very, very common. Now, so what the dependent, the husband or wife, has to do is create some kind of evidence that they did in fact approach their European national partner and requested these documents. So letters to the partner, recorded delivery letters, all those things help in at a later stage in demonstrating to the Home Office that indeed the applicant, the dependent, did make an effort to get the requisite documents, evidence of the European nationals' activity as at the time of a divorce. But let's say you do manage to fulfill even that criteria. So first of all, you've been married for 3 years. Secondly, you've lived in the UK with your partner for 1 year. Thirdly, as at the date the decree absolute is granted, your European national partner is working and you can demonstrate that, or you can demonstrate that you've made an effort to get those documents. There is simply then a fourth requirement which needs to be fulfilled, which is to some extent one of the easier bits to this to the requirements that need to be fulfilled. Fourth requirement is simply that as at the date of divorce, you as the dependent also need to demonstrate that you were exercising treaty rights working in the United Kingdom, which is normally something which is in the hands of the applicant, and the applicant can easily demonstrate that. So if that is the case, then the dependent has an option. The dependent can apply for their own visa, which is a retained rights of residence visa, or the dependent can say, look, I'm not going to make any applications at the moment. I'll complete my 5 years in the UK. So those 5 years will be made up of the time that he or she has lived in the UK with the European national, and also the time where the divorce has taken place and the dependent has lived on his or her own in the United Kingdom. So it could be, for example, 2.5 years in the United Kingdom as a married person, 2.5 years in the United Kingdom as a single person having divorced the European national. So the time frame, the whole 5 years, could be made up with that. Let me just take our next call before we carry on with this. Hello, Assalamu alaikum.
Walaikum salam.
Ji, thank you for calling. What's your
Thank you very
question?
much. Just a quick question. One of my friends is getting married in Pakistan next month.
Okay, yeah.
And I just want to know, well, he just wants to know what documents are required to get his wife to the UK.
Okay, so in terms of your friend, is he employed in the United Kingdom? Is he earning 18,600? Yeah. Okay. I mean, to be quite honest, I mean, there's a sort of a list of there's a whole list of things that need to be submitted with the application. But sometimes the easiest way to look at it is to look at, if you break it down into certain segments, one is the financial requirement, the other is the accommodation requirement, the other is the marriage and the genuineness of the marriage requirement, generally speaking. Now, what you tend to find is finances is normally the main issue. So your friend would need to be earning £18,600 per year. And what the documents that need to be submitted deal with is the last 6 months, generally speaking. So in those 6 months, if he can demonstrate he's on a salary which is 18,600 or more, he will need to submit 6 months wage slips, 6 months bank statements, and an employer's letter which confirms his job, how long he's been there, what he earns, how long he's been on that salary, and whether the job is permanent or not. So normally the starting point is focus on finances and make sure the finances are right. As far as the accommodation is concerned, it's normally straightforward. All you need to submit is evidence that the accommodation is available, property inspection report showing how big the property is, and the owner giving permission for the person to live at the property. So accommodation is not normally a problem. The key issue in these applications is finances. Is the finances in order? Thirdly, on the relationship front, normally once you've submitted the marriage certificate, it's not enough just to show the marriage, but the issue is whether the marriage is subsisting or not. So the kind of documents you're going to have is marriage photographs, after the wedding photographs when the couple have been out and about, telephone records where people have been parties have been talking, WhatsApp messages, any money sent to the partner abroad, so anything that demonstrate that they're in a subsisting relationship, that helps. So normally if you break it down into three: finances, accommodation, and the marriage and the relationship, that normally are the key things that need to be demonstrated. In addition to which, there are two things that the applicant in their home country, let's say Pakistan, needs to do, which is pass an English test, which is the A1 Life Skills test. And that's a certificate which is valid for 2 years. So you need to get the A1 Life Skills test. And the second requirement is that he or she will need to get a TB certificate, basically confirming that there's no the person does not suffer from TB. That certificate is valid for 6 months, so that's normally done towards the end when the application is ready to be submitted. But broadly speaking, that's how an application is put together. I don't know whether that helps you at all or not, or whether you've got any specific questions on that. But generally speaking, that's how a spouse application is put together: finances, accommodation, the marriage and subsistence of the relationship, and there are some documents specifically you need from Pakistan, which is the English certificate, the TB certificate, and obviously the Nikah-nama, etc., which relates to the marriage. I mean, if you look at it logically, you can normally tell what there's some logic behind what the Home Office does request when you make a spouse application to come to the United Kingdom. Unfortunately, that does bring us to the end of the show. Thank you very much for the calls that we've received. Hopefully we'll be back next week on Monday at 6 o'clock. Until then, Assalamu alaikum.